Hello, and welcome to our periodic webinars in the Syracuse Technology Commercialization Law Program and Syracuse Intellectual Property Law Institute series. This is Professor Ghosh, who teaches at Syracuse, and I'm very proud and pleased to introduce Professor Mark Bartholomew from the University at Buffalo Law School, who's spoken to us before, I think on a number of occasions in the area of trademark. Welcome again, Mark. And today he's going to talk about a paper called The Law of Advertising Outrage that came out in Advertising and Society Quarterly, which I hope I didn't mangle anything there, but you can correct me. So Mark, I look forward to having a good exchange as usual, and I'd like to learn more about the paper. Thanks.
Well, thanks for having me here, Shubha. I look forward to talking. Every time I've been on this program, it's been a fun discussion that's helped my work. So I'm looking forward to talking about this. I guess if it's okay, I'd just like to start out by talking about why I chose this topic, right?
Sure.
Advertising outrage, what does that mean? And what got me interested was just, I feel at least, in 2020, but for the last few years, I see that word outrage all the time. This is an outrage. Social media is causing outrage, and it got me to think more about, well, what is it about this time where the word outrage has become so prevalent? And actually, if you do the Google metric where you calculate how often a word appears in books over time, there has been a spike beginning in the mid-2000s and then continuing to climb upward of use of this term outrage. And I think the way we typically think of it these days is associated with social media, that somehow social media is serving up this diet of things that get us angry, get us upset. And is that something that we should be worried about, or at least try to interrogate more? Because I've seen that term thrown around, outrage, without interrogating a lot. So I started thinking about that. And then I got interested in how this term is applied to advertising, because it turns out that advertisers for a while have studied this concept of outrage and how to shock their audiences, but in a way that's profitable, of course. So there's this whole study of an area called shockvertising or shock advertising. And the idea here is to get people upset, but in a way that captures their attention without upsetting them so much that they run into the arms of a competitor. And so that interested me because it kind of tilts against the conventional wisdom, I think, of we tend to think of advertisers just wanting to win us over, have things that are kind of like a warm bath that we enjoy, that are pleasurable to step in. And here's advertisers actually trying to poke and prod us with the emotions of anger and disgust. And then looking into that also got me to analyze, well, how does advertising law handle this? And advertising law, I think we tend to think of, again, the conventional wisdom, as, well, it regulates information flows. It's really about preventing people from being deceived under false pretenses. That's the goal of advertising law. But I think there's this little area where advertising law isn't about preventing people from being deceived. It's about protecting our emotional sensibilities, about preventing us from being emotionally upset, from being outraged. And so that's really the genesis of the paper. And I hope that wasn't too long-winded way of introducing things. I wanted to—
No, lot to explore there. So.
Yeah, there's some things to unpack there about, well, how does this work? How long has it been going on? How's the law handle this? How does technology change all this? And then how should we feel about it? I try not to make a lot of normative claims in the paper. It's mostly descriptive, but we can get into a discussion normatively. How should we feel about advertising outrage?
Wonderful. So did you want to present your PowerPoints, or should
Yeah.
I have lots of questions I could barrage you with, but I think that might not be the most productive.
Yeah. So let me share here, and I'll just offer kind of a brief introduction. Okay, so that should be up.
It's not up on my end yet, so.
All right. Let's see. Okay, sorry, it's saying my screen sharing is paused. Bear with me one moment here.
It's okay.
How's that?
There you go. Perfect.
Okay, sorry about that.
No.
Okay. Yeah, so advertising outrage. Here's one example. And like I said, this is a intentional strategy to get people upset, but in a way that helps the business. And of course, one goal of advertising is to capture our attention, and shocking images, images that violate social norms, that captures our attention. But the concern, of course, is that it will capture our attention in a negative way. We'll see this and we'll think poorly of the advertiser. It turns out, however, that shock advertising has been used in some form for a while here. The thought is that there's ways sometimes to stimulate feelings of anger, upset in audiences, to outrage us in a way that's useful to the advertiser. So let me just give a couple of historical examples. I think you can trace kind of an upsurge in shock advertising during the Great Depression. And so this is an example of what were called the casket cuties. You know, by the standards of the time, this was a scantily clad model draped over a casket to sell mortuary services. And this got people upset. They didn't like it. The average audience member did not like this. But the thought was that this kind of tactic, this shock tactic, was needed to kind of break the logjam of the Depression, where people just weren't interested in consumer goods the way they were before. There's also a litany of examples where all of a sudden Madison Avenue really gets interested in things that weren't talked about politely before: bodily functions, odors, and those things were talked about in very strident copy. You know, you will lose your job. You will be subject to some sort of invasive surgery if you don't use the right brand of toilet paper. And then there's a retreat after the Great Depression, and a more genteel return to more genteel advertising. And then we get to the 1980s, and I'll try just to show a commercial here that was infamous at the time. So this is a commercial for Calvin Klein jeans in the 1980s, and it featured Brooke Shields, who was a model who was only 15 years old at the time. So let me try to play this.
You want to know what comes between me and my Calvins? Nothing.
Calvin Klein jeans.
Okay, well, that was a very controversial ad. Some of the networks refused to run it. Others said, we'll only run it late at night. There were investigations. And I show this because Calvin Klein wasn't the only company. The clothier Benetton was another famous example. But others kind of tried to engineer a shock advertising approach at the time. And as they were doing this, they saw it not as just a one-off, a way to attract attention, but then move back to another way to define their brand. It was a long-term strategy for defining the brand. In fact, Calvin Klein tried to imbue its whole brand with this atmosphere of not just sexuality, but controversial, illegal child sexuality. So in the 1990s, they launched this other campaign, which I'll just show part of. And I think just by watching this, rather than me telling you, you can see why some at least found it objectionable.
Pretty blue eyes.
Thanks.
Where'd you get them from?
I don't know.
What's your name?
Brandon.
How old are you?
20.
Where you from?
Kentucky.
Kentucky?
Yes.
Well, that's where you got the blue eyes.
Mm-hmm.
What are you wearing?
Pardon?
What are you wearing?
Short shorts.
You fit real well.
Thanks.
Uh-huh. Go ahead, show me what you can do.
I'm not sure what to do.
What do you do when you just stand around? And you hear a good song on the radio
I
or CD.
I mosh. I mosh. I like run around the room.
You march?
Yeah, mosh.
Go ahead.
Okay.
That's a pretty good mosh.
Thanks.
You look like a movie star.
Yeah.
Okay, it goes on from there, but maybe I'll stop some of my slides right now. But let me just kind of summarize what the marketing literature says about this stuff. What it says is that it can work. It's very good at capturing our attention. It can work for more than just a short-term strategy. You can see how Calvin Klein built a whole brand over this over a decade plus of the same advertising strategy. But one problem is that it affects different people in different ways. So the heterogeneity of audiences can be a problem, and fit is really important. Shock advertising, outrage advertising can work if the fit isn't so completely divorced that people are upset about it. So what do I mean by fit? I mean, if the product seems to have nothing at all to do with the outrageous content of the ad. So people are willing to tolerate violent graphic images in the service of non-smoking campaigns because it does seem to have something to do with the violence of the body, the ravages of, say, lung cancer or throat cancer. People are willing to tolerate nudity in the service of an HIV awareness campaign because there seems to be a relationship there. And clothiers like Benetton or Calvin Klein, they could say, well, we're trying to have sort of an edgy brand. You know, clothing is so much about projecting a certain persona that audiences might be willing, at least some audiences, more willing to tolerate the use of shock in that context. But picture like a stolid brand, like an insurance company, the use of nudity or violence wouldn't be as acceptable for them. And so we see that shock advertising works, but only in limited quantities, and also always with a danger of kind of blowback if the outrage seemed or the example seemed disproportionate. And what I'm suggesting in the paper has changed is with the use of advertising on social media, there's something I'm calling algorithmic outrage, where we can avoid some of these problems with shock advertising and use it in a much more widespread fashion.
Oh, interesting. Okay. So one of the questions that immediately came to mind, especially as you spoke right now, is your previous presentation here, and your paper was on neuromarks. So is there a neuroscience to this as well? I mean, is there some exploration about what triggers the brain, and how does that work on the advertiser side? Are they doing that sort of thing, or is it just pretty obvious that if you show Brooke Shields strutting around, it's gonna trigger the right sorts of things?
Yeah, no, yeah, I'm glad you asked that. The neuroscientists are involved in this, and with the neuromarks paper, I was able to point to some kind of clear-cut uses of the neuroscience in actual commercials. But I haven't been able to do that here because I think for the most part, the advertisers are kind of keeping that under wraps. It just hasn't become as widespread, but there is a robust academic literature, or at least a significant academic literature, I should say, studying the effects of anger on the brain and different kinds of uses of anger and uses on social media. So there is a lot of studying about exactly how this plays out, and not just relying on people, audiences talking about how this made them feel.
Yeah,
So,
interesting. Yeah.
So yeah, there's definitely a use of that.
And so you talked about lots of different emotions here. You talked about anger, obviously the images, certainly the Brooke Shields images, you know, obviously lust. I mean, I don't want to go through all the 7 deadly sins here, but we can if you want. But I'm just curious if you wanted to kind of take apart this notion of outrage. I mean, you talk once about anger, but I mean, none of these, I mean, I guess I sort of felt a visceral anger at seeing the kids portrayed in this way, and the anger about the Brooke Shields ad having to do with just objectification of women and also children, which isn't clearly what was being intended, I guess, or was it? I just wondered if you wanted to, I'm having a little bit of trouble trying to unpack this notion of outrage.
Yeah, and it's a slippery term, admittedly. I guess a commonly agreed on definition is that it's anger and disgust. It's the combination of those, and it's felt by violations of social norms.
Okay.
So that's a broad tent, but I think you can see how these examples fit under that
Right.
definition. So by itself, it's
Yeah.
not just anger, but this kind of resentment at flaunting social norms in kind of these hot button areas, let's say.
Yeah. So it goes beyond just simply being provocative or controversial. We're talking about it sounds like we're talking about something a bit more visceral than that.
I think so. I mean, the reason the emotion is worth studying and perhaps valuable to the advertisers is that it really short circuits deliberation. Not only is it good at capturing attention, but it's a way to kind of divorce the audience from a lot of thinking about or deliberating about the message. They just know they're upset and they react accordingly.
Yeah. So when you look at this, one of the things, trying to unpack this in terms of the advertising side of the picture is obviously political advertising versus, commercial advertising. And, I think it's only been a week since the last debate, which was a pretty bad advertisement for anything. But certainly, with, I'll say his name. I mean, certainly with President Trump, there is this notion of trying to promote his brand through, tapping into political anger. So, and when I think about controversial ads, now I can bring the coffin cuties into my repertoire of references, but I also think about, the Lyndon Johnson ad against Goldwater, which, was playing to the emotions and playing to a sense of outrage at so many different levels. Obviously, the little girl picking flowers, just evoking, loss of innocence, the bomb versus nature, and obviously the fear of, nuclear destruction that's going on. So, how is this feeding back and forth? Do we see in the literature that it's coming up in the commercial side of things and then the political side picks it up? Or is this, is there something, what is the symbiotic relation? Is there any relationship between the two?
Sure. I mean, I can say, I think a couple things in relation to that. One is that the folks who study how to leverage these things commercially are advising the political campaigns all the time. So it's not like there's a screen between those two camps. There's a back and forth all the time. So I think anything that's useful in the commercial context is useful in the political context, and vice versa. There's a communications scholar named Michael Serrazio at Boston College, and he has this great article where he just interviews these consultants for commercial advertising and for the campaigns, and they repeatedly talk about using the same strategies. No difference if you're selling a candidate, you're selling detergent, you're selling jeans. These same strategies are used back and forth. So I do think there's a synergy here in both camps, I would say. And then the other thing, and maybe this is a good segue, or maybe it's something to talk about later, but the second half of the paper is about how the law understands all this. And one point I have in the paper is that, whereas I think you go back a bit in the past, you see a framework for dealing with this. This isn't about information flows. It's about protecting those audience sensibilities from offensive content in the commercial context. But more recently, with the blurring of the lines between commercial speech and non-commercial speech in the First Amendment, we really see no longer a willingness to say, well, here's the commercial zone. We're more willing to prevent audiences from being offended. Now, in both zones, political and non-political, the sense is, well, anything's fair game. After these cases that I know you know very well, Tam and Brunetti's recent Supreme Court opinions, there's a thought that there's really very little distinction between commercial and non-commercial contexts as far as evaluating things under the First Amendment.
Yeah, well, let's unpack the First Amendment, because there's another kind of society aspect of this that I wanted to explore with you, and that is, I saw the coffin cuties in the context of the Great Depression. I keep thinking of the movie and the Hays Code, and so I wondered about outrage and what is the interplay not between the the ad space and the actual, for lack of a better term, the entertainment or content space. So, I mean, I think about this with television, right? So we always wonder whether the programs are there to promote the advertising or the advertising to promote the programs. So I wonder, how, and I think this is relevant to talking about First Amendment law more broadly, because, when we're thinking about this aspect of outrage, I mean, I think about, Molly Bloom's Soliloquy, or Lady Chatterley's Lover, or, Fanny Hill, or, and we could talk about a whole list of movies that are sort of in the same. So what is that interplay? Before we get to the law aspect, because I think it is interesting that the First Amendment, I mean, that commercial speech versus non-commercial is sort of blurred, I think.
Yeah, that's a great thing to think about. I mean, one thing I can think of is that whole argument that what's the difference between a movie and a television show and a book and these ads? Maybe the current thinking is none. That was a powerful argument in these recent Supreme Court decisions, right? They said, well, if you're going to deny trademark registration, why not deny registration for Lady Chatterley's Lover, or
copyright,
Game of Thrones, or whatever. And of course, we don't want to do that. So once you kind of treat these things the same, then it becomes a lot harder to justify certain restrictions in the commercial sphere. So I think that's one thing we can say, that we're not really willing to tolerate thinking about those things differently, perhaps, or at least that's the attitude of the Supreme Court.
And I don't know where that, I mean, it certainly came up in Citizens United in 2010. I think the first round, as I understand it, suddenly the judges realized that this ad against, against Hillary Clinton was a movie. It wasn't just, it was a movie. So, so if you're going to think about having an injunction against this ad under campaign contribution law, at some point, I think they suddenly realized, how is that different from just censorship of a movie, which the court is. And so, I mean, I don't know if that's the moment in which this line was crossed legally. It's interesting to think about it more, from the society or the cultural standpoint as to when. I mean, the example I think about on this line between is in the movie It Happened One Night. There's this famous scene where Clark Gable takes off his shirt, and I think I forget what kind of T-shirt he's wearing. And apparently the demand for that type of T-shirt went up after that movie came up. So, was that fantastic movie? I think it's one of the first movies to win, all 5, Oscars or whatever. But was that just a big advertisement for T-shirts at the end of the day?
Right. And that's interesting that it was going on, so long ago, and then now it's just that kind of product placement integrated in the movie on steroids, right? That's all over the place. And we can probably even more so now, we're able to skip commercials when we watch things on Netflix and Amazon Prime, but that puts more pressure to integrate these things into the movie. So yeah, there is a sense of, I think, kind of context collapse in a bunch of areas, not just commercial, non-commercial, but entertainment versus business or political.
I mean, it's interesting. I mean, and also if you bring the technological aspect of this, suddenly you have something called radio, right, or television. And now we want to find a way in which to make this platform, just like we think about with the internet, the same question. We have this new platform. We now want to figure out ways to capitalize on it. I may use the word capitalize in various senses of the meaning. And so then we need to think about content. When we think about content, then we need to think about funding content, and that's typically be done by advertising. But then the line between, what's, the tail and the dog kind of blurs at some point there, right, within just the system of promoting these platforms. I mean, that's certainly what's happening with the internet when you're.
Yeah. And so we get, I think, First Amendment doctrine that a lot of people find is unsatisfactory, but it's an effort to generate some categories here to make some distinctions. And on the one hand, it's very problematic. On the other hand, I think you're sensitive to this in some of your writing, and I'm sensitive to it. Sometimes there is a reason to make those distinctions, right? So it's a fraud exercise, and I think sometimes we get frustrated at the Supreme Court, but they are engaging in difficult line drawing, or in the case of some of the more recent cases, erasing certain lines.
Yeah. I mean, it's a basic problem, and I think in certainly in trademark, you see it, I think, in the what you're highlighting, but it comes up in copyright. I remember, when I was teaching where you're teaching at Buffalo, I had one of my students asking me there in copyright law, and that is, well, if U.S. copyright law is about promoting science, which means knowledge, what does Terminator 2 have to do with promoting knowledge? And that was kind of one of these questions where, you just want to say, "Shut up, student." Just no. Obviously, that was a good question, but I mean, I think this whole notion of what we're trying to promote through through knowledge, what that means,
Sure, and I
has
think
changed over time quite a bit. I mean, it maybe is a very flexible meaning. I mean, my response to the student at the time actually was, "Okay, well, you tell Disney that."
Okay. Yeah, I mean, and I think that the answer we've come up with now, a very unsatisfactory answer, is, well, it's just about numbers. It's about sheer production. We
Yeah,
can't
right.
evaluate the, how good it is at this goal of increasing knowledge without, we're not really giving the name knowledge any content. We just say sheer numbers. Doesn't matter if it's the worst movie in the world or the great American novel. We're going to treat it all the same, which is I think unsatisfying to a lot of people.
Yeah, I mean, I guess I've been looking at, and you probably, Fritz Macklep, who's economist of basically of science, of knowledge production. I think I don't know if this is true. I'll say it's true now. I mean, I'm sure we'll get, I don't get any viewer mail for this. I can say it, and I'll turn the comments off. But I think he's often associated with the phrase knowledge economy, or I don't know if information society, but certainly those concepts, if not the actual terms, can be traced to him. And certainly, when you look at it, he understood or saw that a lot of this was about just, and not exactly the dollar value. I don't want to reduce it simply to that, but it was just simply more about quantity, and those qualitative distinctions were just not ones that anybody is willing to make, really, or capable of making. Maybe that's just left to social mores, things like that.
Yeah. And I think that's why I was intrigued by this subject, because it was, in some ways, this whole idea of regulating audiences against shock was sort of a last bastion of this being willing to really engage with speech and advertising regulation on a very qualitative sort of level.
Yeah.
And so in some ways it's a remnant from an earlier age. For a paper a few years ago on morality and trademark law, I looked at how do people define unfair and immoral conduct when it comes to trademark law and unfair competition. And so you look at the older cases and they have all these great definitions. I think my favorite definition of unfair competition was a level of rascality that raises more than an eyebrow. Right? That's a great legal standard, but courts are willing to toss that out all the time and say, this is what's bad, this is what's good. And it's a very different approach today. And not that I think courts are blinded to moral concerns, but trying to articulate those comfortably, that's no longer seems acceptable these days.
Yeah, and that's related to this sort of qualitative words like standards, words like books of learning versus books of entertainment. I mean, are there, I think Graham Greene talked about how some of his books he just viewed as entertainments rather than the serious moral fiction. But I find all his books incredibly entertaining, and also with a sort of moral edge to them, even if you may have thought of them as only entertaining. So it's kind of interesting, which gets us to this regulatory question, or the legal questions, I think, which obviously we want to get to. I mean, one response, I mentioned the Hays Code earlier to things like Outrage, is, I think Hays Code is largely sort of industry self-regulation tied in with some government involvement. I think the post office may have been involved, and these questions about using the mail for distributing obscene material. So there's always this sort of mix of, as I understand it, public and private. For the things like Calvin Klein, from what I remember at the time, there's a big letter. I mean, there's a big, letters to the editor. People, I don't know if people boycotted Calvin Klein or not, but I mean, that's typically one of the responses that goes. And flipping this around a little bit, if viewers are outraged with the content of programs, of TV shows, then they boycott the advertiser. So there's sort of a, so it's kind of really interesting the way in which, all these interplay, as we said. What's your sense about the legal side? I know you were talking about the First Amendment playing a role somehow in this, and then maybe with Tam and Brunetti, that's, as I gather, maybe receding or.
Yeah, let me just sketch a little bit out here, right? So I think there's a variety of governmental agents that had some role, although a much reduced role today, but had some role in the past at under the broad term of advertising outrage, had some role to play in preventing people from being outraged. So one thing we can think of is the FCC. The FCC assert a right to protect people from indecent and profane content. And there's this famous Pacifica case about the comedian George Carlin's 7 dirty words you're not allowed to say, and he said them, and could the FCC prevent that from being on the radio? And one interesting thing, going back to that case, I think Pacifica is from 1978, is in the decision upholding the FCC's ability to prevent these words from being broadcast in the public airwaves, the court emphasized that these words in the program were being sent to the listeners over and over in a sort of verbal shock treatment, they said, shock treatment. So wanting to protect listeners from being shocked by this. We could also say that Congress asserts its role periodically to stop audiences from being shocked. One thing we can point to perhaps is the Communications Decency Act in Section 230, which has this Good Samaritan provision trying to give an incentive to online service providers to take off these offensive things that might shock people who participate on Facebook or Twitter or YouTube, saying, well, you can do that without being deemed a publisher and being held liable for responsible for the content on there. So that's another actor that's involved in this. We have quasi public institutions like the advertising. It's called there's an advertising Advertising Research Council, I think I've said. I'm not getting the acronym right, but anyway, it's a big body that makes a point of promulgating regulations. It even has an adjudicatory arm from the National Association of Advertisers that can police kind of false advertising disputes, but potentially it could regulate when something is too offensive to be allowed to be used in an advertisement. And in fact, when you look at the counterparts across the world, for example, the United Kingdom, they very forcefully say, this is too demeaning of religion, you can't use this ad, or this is too sexist, you can't use this ad. Whereas here, it's taken a more of a hands-off approach. And then you have to look at the private mechanisms for regulating this. And so just kind of briefly, the thesis of the paper, or one of the sub-theses of the paper, is that advertising on social media changes things by making shock advertising more plausible for lots of different advertisers, not just kind of the outliers like Calvin Klein. How does it do this? By targeting, so it can target much more specific audiences and thereby avoid the kind of blowback that you might face with a big ad. Let's think of a Super Bowl ad where your audience is so big that some people will naturally be not just offended, but really, really offended. So example I can give for this is literature showing that, well, when you offer a shocking ad, people will be shocked, but they'll be less offended, less shocked if the actors using the ad are of a different ethnicity than the audience. So we can see this with these ads on the internet. They've been targeted to particular racial demographics, and then the actors using the ad are of a different racial demographic to upset people, but not as much as if they kind of saw themselves in the actors. So that's one thing that makes social media shock advertising different. Another thing I think that makes it different is that you can kind of obscure the advertiser's role to a certain degree, because we're skeptical of ads. We can see the role of ads, but if it's shared by someone else, then we're more willing to take a look and engage with the ad. And so a lot of these ads are meant for sharing with your group online. And in a way, I think that obfuscates the advertiser's role if someone in your group is sharing the ad with you, as opposed to the advertiser putting that in, say, a glossy magazine spread. And so I just want to introduce that when I talk about private regulation, because we've always had private regulators. The New York Times still has provisions in its advertising policy saying vulgar and profane advertisements we will refuse to run. NBC has the same kind of standards department. And Facebook does as well, but whereas NBC actually has promulgated opinions you can grab onto, it actually has, these are the reasons why I refuse to run your ad. And same with the New York Times to a certain degree. Facebook and Twitter and YouTube have been pretty cagey about this stuff. They have community standards, they have certain restrictions on violence, but they're kind of ambiguous. They haven't released all these things. And I think that's a feature for them, not a bug, in that they can pick and choose kind of when they want these things to be on people's fields of vision and when they don't. And so I think you have to treat Facebook, along with the more traditional parties like the television networks and the newspapers like New York Times, all as regulators in this sphere to have a role to play. But I would say the social media platforms are playing a role where they're a little more willing to allow some rope to the advertisers to engage in this kind of shock advertising.
Yeah, let's. I mean, there's so many things to talk about. I mean, I'd like to get back to that. I mean, maybe we could end by talking about that. Let's talk a little bit about where you think Tam and Brunetti fit into this picture. I mean, those are big, high-profile trademark cases. So,
Yeah.
I think of the range of regulatory possibilities you mentioned, I think you hinted at trademark. But is trademark law now off the table with Tam and Brunetti, or?
Yeah, and if with your permission, can I show a couple more slides?
Oh no, you don't need my. Yeah,
just for audience members perhaps who aren't familiar already with Tam and Brunetti. Okay, so let me get my. First, I'll have this initially up here, right? So sorry, I won't let our eyes linger on this for too long, but trademark law has two statutory provisions that bar the federal registration of scandalous marks and disparaging marks. So scandalous marks are ones that are offensive to the general public. And so here's an example. There was this logo that shows this defecating dog, and the Patent and Trademark Office said, oh, that's scandalous. People don't want to see a defecating dog. That would offend people. And these provisions had been in the law for decades, and they're found in the trademark law of other countries. The United States was definitely not an outlier in having these provisions that prevented scandalous and disparaging marks from being registered. But then a few years ago, this Asian dance rock band called the Slants had tried to register the name the Slants for their band. It was denied for being disparaging to Asian Americans, and they challenged this determination, wound its way through the courts, and eventually made its way up to the Supreme Court. And then I think it was 2017, the Supreme Court said, this provision offends the First Amendment. You can't have the Trademark Office saying that, well, if a message is offensive to a group, we'll disallow it. But if it's celebrating a group, if the mark was, up with Asian Americans, that would be okay. They said, no, that's an offensive content-based discrimination that runs afoul of the First Amendment. And so we have that example, and then we have this case Brunetti, which is about this trademark that you can see on the model's t-shirt here. And that case made the Supreme Court just last year. And you might ask yourself, well, how did the Patent and Trademark Office have any hope of succeeding if they'd already been told that the disparagement bar already violated the First Amendment? And the thinking is that well, we still can save the scandalousness bar because that doesn't really offend on the basis of viewpoints. Unlike saying, well, we're going to tolerate points of view that are celebratory of races or religions, but not the ones that are critical of them. That seems like viewpoint discrimination. Here for scandalousness, we just say, well, anything that just is so vulgar or profane that's offensive to people, those are the things that we'll disallow. And so maybe that isn't quite the same kind of viewpoint discrimination. And the Supreme Court is really having none of that. They said, oh, no, this is viewpoint discrimination, and we're going to treat it just the same as the disparagement bar. And the reason I think that's relevant here is it's, once again, this sense that we're not going to draw lines between the commercial and the non-commercial. One argument that was advanced was, well, this is trademarks. This is, you know, the machinery of commerce. Isn't this a commercial kind of thing? And so for that reason, we're willing to tolerate more limits on free speech. We're more willing to give credence to government interests. And for a long time, there has been a distinction made between commercial and non-commercial speech along those lines. But I think Tam and Brunetti, you know, they're kind of fractured opinions in both those cases. Yeah. But they really seem to say, for the most part, we're not really going to draw a distinction here. We're going to say that in either sphere, we're not willing to conceive of any interest in protecting audiences from shocking or offensive tactics. And I think I told you, Shubha, that just today I had to teach Tam in class, and reading the opinion today, one thing that was interesting is they said, yeah, you know, this isn't really giving audiences credit, because sure, they'll be offended at first, but then they'll rationally deliberate. And I think the words even used were, after a pause, the audience will have a chance to deliberate, just as they would in the political realm. Maybe there'll be a shocking ad, like that Goldwater ad you talked about for Lyndon Johnson, but then there'll be some thoughtful reflection on this. And the thought is, maybe you're shocked by the Slants name, but after thoughtful reflection, you think, oh yeah, that's I understand why that's offensive, but I appreciate this effort to kind of take the name back by this Asian American dance group, and maybe it'll neuter the term of its power. So there's thought is, even in the commercial sphere, we shouldn't tolerate restrictions on shock advertising. Let people think about it.
Right. So I mean, that's sort of suggesting, this is getting just to another dimension of what we mean by outrage at the beginning, right? So somehow, I guess if I understand the reasoning as you characterize it correctly, it's like, oh, come on now, you shouldn't be outraged is basically the response, right? Or you shouldn't have that response. Just be rational, just think about it. And I guess, you know, this, you know, maybe I'm not, maybe I'm reading too much into what you're saying. That seems to totally contradict what we said about outrage, you know, half an hour ago or something, right? That there is this notion of the lizard brain, you know, that the advertisers are trying to appeal to. So how should we interpret, you know, what you're finding in the Tam opinion? Is the court trying to counter the lizard brain by saying, you know, we should be just more, and that also has a very interesting kind of moral dimension to it, right? Because, you know, it's the civilizing influence you need to bring. You know, anyway, you see where I'm going with this.
Yeah. I think there's a bunch of great things to unpack there. One thing that's interesting is just the historical treatment of outrage and anger. And, you know, going back to Plato talked about how is this unacceptable emotion. There's no reason to ever feel angry. It's not deliberative. And then Aristotle thought, well, actually, anger in the right frame can be kind of virtuous. It's perfectly acceptable to be angry. And we see this ebb and flow, you know, across time, even in the Victorian area. Well, it's okay for a man to be angry out in the commercial marketplace. Never okay to show it at home. That's not an acceptable emotion in that sphere. So it's interesting to think about that. You know, when I think about that language in the Tam opinion, I do think it's sort of unrealistic or not fully grappling with the way all of us process advertising. Advertisers have been onto the lizard brain for some time, and the world would not look the way it did if we always rationally processed advertising. It would look far, far different. So that's not to say that that means that we should always be protected from emotional or outrageous advertising tactics. There might be good reasons to still allow that kind of advertising strategy, but you have to look, I think, at different consequences to that regulation and not say, oh, well, you should just process this rationally, because we don't. And I think the literature on shock advertising says it's attractive precisely because we don't at all when it comes to things that we feel outraged about.
Yeah, so I mean, I this is reading a lot, and you probably are more up in this than I am, but I'm thinking about, for example, some of the battles over sexual content in literature and also in movies, right? So that people will read this stuff and get so aroused. And I know some of the other tests of obscenity kind of, I don't remember all of them off the top of my head, tried to play off of these different types of things. But I think at least as a cultural matter and maybe as a legal matter, there was sort of an understanding that, well, it's just words on a page. And I mean, there is sort of this dimension that you sort of control your lustful instincts, and we know how to challenge that. And not to trivialize this, we've all had high school hygiene class and things like that, and we know the proper place for sex. Therefore, we don't need to suppress it in this way because of I'll use the word civilizing influence. And I wonder if something similar is happening with outrage. I guess on one hand, it's interesting if that's what's happening. On the other hand, it just seems totally inconsistent with what I see, that people are somehow learning to channel anger, and in the same way that we're supposed to have learned to channel lust.
Yeah. We don't seem to be becoming more civilized. 2020 is a dark year. Maybe we'll become more civilized in 2021, but it doesn't seem like it. Yeah. And one thing that the literature on outrage says is that it's particularly powerful for advertisers because it is an emotion that demands to be shared. You want to perform your outrage to other people. So it's great if you can be outraged by something, because then you share it online and it circulates more and more. And these platforms, of course, re-emphasize that, right? When you look at the auction process for how much you have to pay to advertise on Facebook, it's not just the amount you're willing to pay. Facebook also weighs, well, how much is this ad likely to be shared? If it's more likely to be shared, I'll give you a discount. You don't have to pay as much as someone else who has kind of a boring ad. And so that further reinforces this. And so I think outrage breeds more outrage. It's not something where I think we're going to feel less outraged. At least that's one way to look at it. The other way to look at it, though, I think some people would argue is, well, there's a danger in kind of trivializing outrage, right? If there's a finite capacity for it, then don't we want to feel outrage for the things that really are outrageous? And you see this talked about all the time in politics these days. We can't keep up. There's so many outrageous things, so forget about the thing before. There's a great article in the Atlantic, I think from 2019, where they introduce all these things. Weren't you outraged about this? This thing this celebrity did. Weren't you outraged by this ad? And as a reader, you think, no, I wasn't at all. And they say, well, why is that? Because it was from 2014. We tend to think of outrage as this phenomenon that's really 2019, 2020, 2018, but it's been kind of brewing in the culture for the last few years. And so one thing we have to wonder is, will we become drained of our capacity at a certain point? So far, I don't think we have. Maybe subject to diminishing returns over time.
Yeah, I mean, that is interesting. I mean, we're getting into, I think, what your research really here and also in your neuromarks papers, is the role of the emotions and passions in law. I mean, that's sort of what's at the background. And I mean, even going back to this issue of sexual content and lustful thoughts, I mean, I guess the law does have this distinction between obscenity and pornography, where the obscenity is the thing that is kind of this doesn't totally track the legal definition, but does go to more of these kind of animal, non-rational, non-scientific, not to go back to the copyright term, not knowledge-inducing or educational aspect. And of course, critics of that distinction who criticize pornography, whether from a feminist perspective or religious, whatever it might be, also says, well, there's nothing rational about that either. I mean, there's nothing educational. It's purely lust-inducing, whatever it might be. So what I'm getting to that is maybe, this notion of outrage, there's some distinction that's going to emerge over time. Maybe that distinction, what you're suggesting with the 2014, we have this hot news category, in information law. Maybe there's such a thing as hot outrage that, we want to sort of deal with, and then there might be more this cooling off outrage that, those are facts, right? Hot news becomes facts, right? And then facts become in the public domain. Maybe something like that is happening here with, if there are sort of emerging categories to make sense of this mess.
I love that. Yeah. What would Justice Brandeis think of this? Yeah. So that makes me think of the reasoning in the Brunetti case, right? So the Brunetti case holds that the scandalousness bar fails, it violates the First Amendment, get rid of it. But one thing that was interesting is, whereas I think almost nobody on the court in the Tam case about the slants and disparagement bar was sympathetic to keeping it, there was a lot of sympathy. They were kind of, and all these kind of separate opinions, the judges were very wistful of getting rid of the scandalousness bar, because I think there was a place they saw for these things that do appeal so much to our reptilian brain. They can't be about being deliberative at all, including, I think, the word, F-U-C-T. They said, well, we would love to see a statute that was tailored to not allow that there. And it's not just obscenity, things that are sexually vulgar. I think they were willing to say, yeah, we totally endorse a statute that just prescribed that. The problem was that this was too broad, the word scandalousness, and it seemed to encompass things that were immoral as well, and it gave the government agency too much license. But there is so much, I think, nostalgia for having some way to cabin, allowing marks that were explicitly profane or sexual, even so much that in some of these opinions, you saw the justices really, I think, contradicting themselves 2 years earlier in the Tam case.
Right. I certainly saw that with Justice Roberts' opinion. He seemed to be hemming and hawing in his concurrence, if I remember correctly. It was like, is this viewpoint, or I don't remember the precise language right now, but there seemed to be this kind of confusion. Certainly. One of the things we haven't really talked about in the trademark context here and I always thought was relevant, is just the creativity aspect of trademark. I think one of the issues people had is, shouldn't there just be a naked rule that says you couldn't just, I'll be a little vulgar here, I guess it's my webcast, so whatever, but I'll take the hit here. Could somebody just simply trademark the word fuck, F-U-C-K, by itself, or just the word shit by itself? And that, I think people are sort of, that seems odd that you can now trademark that. And I would think that the distinctiveness bar, to the extent that there's a creativity aspect to that, would preclude you just from doing like these just blatant profanities. That, I think fuck works, F-U-C-T works, because I think that's pretty creative. F-C-U-K strikes me as pretty creative and clever, but maybe it's just my warped sense of humor. But once you recognize if there is a creative aspect to this, the standard of distinctiveness, which is what that's what 1052 starts off with, right? It's about, what is distinctiveness, and then it has these exclusions for distinctiveness. I think I always wondered, to the extent that these threshold things have any bite in IP, whether it's originality and copyright or patentable subject matter and patents. It always struck me that would be a bar from just simply a blanket trademarking of a profanity like the N word or the H word or the C word, or whatever it might be, versus these slight kind of clever variations.
Yeah, maybe we'll see some creative development of that case law now. I will say, and I know this, that there are a flood of marks that are being successfully registered now that are these words that, like you just said, that would have
Just
failed the
yeah.
scandalousness bar, and now they're being registered as trademarks. But maybe we'll get a case down the road that says, well, no, but it's not distinctive enough, or I think there's the mark has to function as a mark, so maybe that's a way. I know there's a case about trying to register a swastika as a trademark, and the denial said, well, no, it doesn't function as a trademark. People just don't see that as a source identifier. So
Yeah, no, that's interesting, right? Which is getting to the distinctiveness. Yeah, I mean, this is where the distinctiveness comes into play, and whether there are certain symbols like the swastika that just have, or a burning cross, that just have a inherent meaning that, this is kind of the argument for why slants, why people were offended by the slants being registered. It's just that they're just certain words that have inherent meanings that there's no play with, right? So,
yeah,
and maybe that's what will emerge. I'm sorry, I didn't mean to interrupt.
Oh no, and that makes me think, it taps into certain categories of speech that we think they can't do the job of communicating the way other words are. So it's the reason we treat fighting words the way we do and allow those regulated by the state. And that was an argument made for these things. Well, people just get mad when they see these racist terms or these sexual vulgarities. They can't possibly really serve as source identifiers. So that's why you should allow us to disallow them. But the court's answer was, well, we'll leave that for another day, but we're not comfortable with explicitly saying you can't register this because we find it offensive.
Yeah, right. I mean, which, it's a question of the categories, how are these categories gonna, and maybe the problem arose is that it maybe wasn't specific enough. But then you get into some interesting First Amendment. That means the more specific that you censor something or you not allow something, that the less of the First Amendment protection there is. But that seems to run up against some problems, I would think, eventually. Right? So, but this was great. I know we've spoken for an hour and there's so much to cover. I wanted to give you some time to sort of have the last word and maybe talk about future research projects. We got into the social media regulation and even hinted at some of the Section 230 issues that are at the background to all of this. But why don't you take maybe a few minutes if you wanted to maybe talk about what future directions for your research on this topic, or?
Sure. This has been a lot of fun to talk about. I mean, one thing that I would like to think about in this, and I'd love to get anybody's thoughts, is, so that's kind of the description of what's going on, but how should we think about this? Should we object to being outraged, and should these legal regulators do anything about it? And so as we've talked in this discussion, it makes me think about consumer agency, just thinking about how good are we at resisting this? Are we capable of making the trade-off? I think some might say, well, it's kind of like, I'm going to put up with that terrible presentation to get a timeshare just so I can get the free trip kind of thing. And I'm a rational adult, I'm going to put up with that. But is it possible for me to rationally say I'm willing to be outraged to take advantage of the free service of Facebook or the free service of YouTube? And I don't know how well we are at making those kinds of trade-offs. It also makes me think about how responsive are these platforms. So there's a great article called The New Governors by Kate Klonick about exactly how these platforms engage in content moderation. And there's a lot of great stuff in there about, well, this is the unspoken rule and how they negotiate this. But one thing that article says, which I take a little bit of objection to, is saying these platforms are engineered to be very responsive to what people want. So if people really don't like being offended, the platforms will change. And I think she's talking about graphic violence, appeals to terrorism, and we see Facebook and Twitter trying to adjust their metrics to allow less of that. But I'm not so sure about outrage and shock. I think that there's a value in the bottom line for Facebook and Twitter and these platforms to shock us and outrage us to a certain degree. And so I'm not sure, even if we wish we were offended less online, if the social media platforms would be willing to do that for us. And so the last thing I think to think about, and I've just preliminary started to work on this, is to think about, is there some kind of core interest here in not having our emotions leveraged in this way? Is it somehow part of our right to privacy to maintain a kind of emotional equilibrium, and this kind of advertising or this kind of cloaked regulation of shock advertising is not serving our interests in the right way? And I don't have an answer on that yet, but I think it's something you can think about, particularly if, I like your idea about kind of hot news morphing to hot outrage. If we want that to happen, how do we articulate the interest in the right way to nudge the law in the right direction?
Yeah. Well, this is great. And one thing I really like the paper, I'll do links to it. And, I forgot to mention, I always try to cite Albert Hirschman's The Passions and the Interests, because I think it's a great book. But, when you mention this notion of controlling outrage and thinking about the interest and whatnot, it immediately thought about that direction of research. But that's probably another podcast, or maybe it's just me talking to myself about these things. But thank you so much. It was really great. And I'll put in links to the article and your other work. So thanks again, Mark.
Thank you. This was great.